Hello, my name is Joseph Greenlee, and this is the fourth in a series of videos in which I will be interviewing authors about their Second Amendment scholarship. Today we are joined by Robert Cottrol. Bob is the Harold Paul Green Research Professor of Law at George Washington University Law School, where he specializes in American and comparative legal history and also teaches criminal law. He has authored four legal history books on race and law. He's the editor of a three-volume anthology on the right to arms and has published several law review articles as well. His research has been cited by the U.S. Supreme Court, the Third, Fourth, Fifth, Ninth, and D.C. Circuit Courts of Appeals, as well as several district courts. Today we will be discussing Bob's newest book called To Trust the People with Arms, which he co-authored with Brandon Denning. And the full title is To Trust the People with Arms, the Supreme Court, and the Second Amendment. So thank you, Bob, very much for joining us.
Glad to be here.
So the first two-thirds of the book focus on the history of the right to arms in England and mostly America, seemingly with an eye towards the debate that would occur in the latter half of the 20th century over whether the Second Amendment protects an individual right or some sort of collective right. We'll work our way up to that debate, but so the viewers can keep that in mind as we go through this interview, can you please explain those different interpretations of the right?
Well, we've had, I think, for most of our lives, been hearing the debate of whether or not the Second Amendment protects an individual right to keep and bear arms, as indeed the language suggests, the right of the people to keep and bear arms shall not be infringed, or is it simply somehow a right that's either a right of the states to maintain militias or a right of people in the militia to have arms. Let me say that debate is really very much a product of the 20th century gun control debate. It starts fairly early in the 20th century, and we'll get into that, I think, a bit later, but it really heats up from the 1960s on forward when you have a gun control movement which is frankly a gun prohibition movement. And they make no denial of that, at least at the beginning, that their ultimate aim is large-scale prohibition of firearms ownership. And the tool with which they intended or helped to achieve that was a reinterpretation of the Second Amendment so that it would essentially be meaningless in terms of any right of individuals in their private capacity to possess firearms. So, in part, what we're doing is we're looking at the beginnings and the history of that debate. But actually, I think we're doing something a little more fascinating, which is uh, our major focus of the book, and this is true despite subsequent cases, is how did we get to Heller? How did we get to District of Columbia versus Heller? The first time that the Supreme Court explicitly recognizes the Second Amendment as protecting a right of individuals and setting real limits on what the government can do in terms of firearms regulation. And that's a fascinating story. It's a story of a right that was considered in the late 18th and early 19th century, the founding era, to be fundamental, one that could not be denied free people, and one that by the 1970s, let's say, um, all of the our great thinkers, quote unquote, were saying that the Second Amendment was essentially meaningless in terms of protection of an individual right. And so the question is, how did we go from there to the real turnaround that Heller and the subsequent cases, McDonald and Bruin, represent? And that's part of it. And part of it it's one of the great turnarounds, I think, in American jurisprudence. I would liken it to the Supreme Court's turnaround with respect to separate but equal from Plessy versus Ferguson to Brown versus Board of Education. How does the judiciary come to think anew and to look at something with perhaps fresh eyes? And so that's part of what we're doing with this story.
So the American right to keep and bear arms has long been understood as having been inherited from our English ancestors, the English right having been recognized in the 1689 English Bill of Rights, which declared that the subjects which are Protestants may have arms for their defense, suitable to their conditions, and as allowed by law. But you know that from the earliest colonial days, in America, the right has always been broader, largely out of necessity. So, what were the circumstances in colonial America that brought about this robust right to keep and bear arms?
Well, I think several things contributed to it. One, you didn't have um, you didn't have the English military and police presence that you did in England. So there was always a recognition from the beginning that the defense of particular colonies would fall to the people of those colonies and not necessarily to English law enforcement or English military forces. Now, that had been true in England to some extent, which is there had always been in England a traditional reliance on the posse comitatus and the militia for defense. But those ideas or those notions or institutions are greatly strengthened in the American colonies. And the American colonies um, are vulnerable on several levels. One, they're bordering on hostile French and Spanish colonies. There's an indigenous population, the Indian population, and there's racial conflict. Certainly, in slavery exists, for example, throughout the 13 colonies. And there, a number of the colonists are looking for methods of slave control. So all of those things contribute to a strengthening of the notion of a right to bear arms as being essential for the survival of a community.
Well, we get through the colonial era up to the founding era. The founders are now debating the Constitution and subsequently the Bill of Rights. What was the focus of those debates when it came to the right to keep and bear arms?
Well, actually, it's interesting. The right to bear arms is not a subject of hot debate at the time of the framing of the Constitution. There, there is, I think, a general consensus that the right to bear arms is an important right. The real dispute is over the militia, and to give it a very oversimplified thumbnail sketch, I think that it's fair to say that the anti-federalist forces, those forces that are skeptical of the new Constitution, want strong guarantees that would guarantee state autonomy of the state militias and state control over the state militias. The Federalists want, to a great extent, a militia that's going to be under the control of Congress and is going to be, in fact, effective for defense of the new nation against both external and internal hostile forces. And Madison himself, who is writing the Bill of Rights and indeed the Constitution more generally. Madison is skeptical of the very idea of a Bill of Rights. I mean, his view is to say that A, B, and C are constitutionally protected is to imply that there are other rights which can be infringed, can be interfered with. So Madison initially cautions against the idea of a Bill of Rights to begin with. He says, look, what will protect individual rights are structural guarantees, separation of powers, federalism. Those things are better suited to protect people's rights than a listing of rights. However, he has to get some of the anti-federalists to sign on to the new Constitution. So he's getting bombarded with all sorts of rights that should be put into the Constitution. One of which is the anti-federalists are saying, let's have state control or stronger state control over the militia. Others are saying let's protect the right to bear arms. And I think what Madison does is something very interesting. He drafts a provision, which we all know, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the final version. There are previous versions, but that's the version that comes down through history and we have today. And if you look at it, I think that what Madison is doing is he's giving a nod to the concept of the militia. The militia is an important thing. A well-regulated militia is necessary to the security of a free state. That's acknowledging the concerns, the anti-federalist concerns over wanting a more independent militia and more state control of the militia. But the language doesn't do that. The language simply says that a well-regulated militia is important. It's necessary. The guarantee that is put forward is the right of the people to keep and bear arms shall not be infringed. So it makes a nod, I think, to the anti-federalists. And in terms of the guarantee, in terms of the imperative that is captured by that provision, the imperative is that the right to bear arms shall not be infringed. And now they're related because certainly in the 18th century, a militia is basically composed of the citizenry who are expected to come bringing their own arms should there be an invasion or rebellion or other need for the militia. But the language alone does nothing, it seems to me, to guarantee the militia. But it does very much clearly state that the right of the people to keep and bear arms shall not be infringed. And I think what's interesting is where Madison's initial placement of the Second Amendment, I think, is very important, or what becomes the Second Amendment is very important. We're accustomed to the Bill of Rights as a separate document, apart from the main body of the Constitution, something that was enacted afterwards and exists on a separate basis. Madison didn't see it that way. He initially wanted to intersperse the different provisions of the Bill of Rights in the main body of the Constitution. And his initial placement of what is now the Second Amendment was in Article 9, was specifying individual rights, including habeas corpus, for example, and not in Article 8, which discussed Congress's power over the militia. Had his major concern been, or his major focus been, modifying Congress's power over the militia, he would have placed what became the Second Amendment in Article 8, as opposed to Article 9, which is concerned with rights of the individual.
So after discussing the founding era, we move on. You highlight some commentaries by influential scholars, including Supreme Court Justice James Wilson, William Rawle, St. George Tucker, all of whom discuss the Second Amendment in the context of an individual right. And then you discuss gun controls in the first half of the 19th century, which largely consisted of requirements that Black people, but not white people, acquire a license before being able to possess arms. And this, skipping ahead quite a bit, but this brings us ultimately to the 14th Amendment, which was drafted in 1866, ultimately ratified in 1868. And this is a broad question, but what effect did the ratifiers of the 14th Amendment intend for it to have on the right to keep and bear arms?
Well, I think the proposers and ratifiers of the 14th Amendment meant for the 14th Amendment to be two things. One, a revolution in terms of race. The last statement by the Supreme Court on race relations had been the Dred Scott decision before the Civil War, where, among other things, Chief Justice Taney at the time, said that black people could not be citizens, and therefore were not entitled to the rights of citizens. The 14th Amendment made crystal clear that persons born in the United States were in fact citizens of the United States, regardless of race. So that was a revolution in terms of race relations the 14th Amendment was meant to produce. And to a great extent, it does, though not as much as it should have, but we can get into that a bit later. But the 14th Amendment also, I think, had another purpose, which was a revolution in federalism. The antebellum federalism as it was conceived before the Civil War, and as the Supreme Court had mentioned, basically said that the rights of the individual against state governments were not protected by the US Constitution. And more specifically, that the Bill of Rights did not apply to the states. That the First Amendment, the Second Amendment, the Fourth, the Third, all of them were limitations solely on the federal government and not on the state governments. The drafters and ratifiers of the 14th Amendment intended to turn that around, to say that the 14th Amendment brings the federal Bill of Rights within the purview of federal courts and Congress in terms of protecting the individual from state action. Very soon after the enactment of the 14th Amendment, the Supreme Court in the Slaughterhouse cases basically said that the Privileges or Immunities Clause, which is a provision of the 14th Amendment, really did nothing to protect, or very little to protect people from the actions of state government. And so we end the Reconstruction period with the reigning doctrine still essentially being the doctrine that existed before the Civil War, which is that the Bill of Rights did not protect people from actions by the state government. And what's interesting is that the Supreme Court would then spend the rest of the 20th century, and indeed the 21st century, and I think McDonald was very important in that aspect, of essentially redoing what it had gotten wrong in the Slaughterhouse cases, and basically saying, yes, the Bill of Rights is a limitation on state government, as well as the federal government. That too is a fascinating part of the story, which is how we went from that denial of that the Bill of Rights was a limitation on state government to finally an embrace of that, of which I think McDonald was a major sort of last plank in that building, if you will.
And so even though the 14th Amendment wasn't throughout the end of the 19th century viewed as a limitation, in some places like Georgia Supreme Court held that Second Amendment applied to the state. But even though it didn't immediately accomplish what perhaps the ratifiers of the 14th Amendment intended, you nevertheless write that, quote, "It is fair to say that the 19th century ended with little disagreement that the right to keep and bear arms was a fundamental right of Americans," unquote. That would not be the case at the end of the 20th century. We first saw this in the 1905 case of Salina versus Blakesley, which you address in the book, where the Kansas Supreme Court held that the Kansas Constitution protected only the right of militiamen performing militia duties. But then the first...
I want to say a few words about Salina because I think it's important to think about. If you think of the current debate that we're familiar with on is it an individual right or is it a collective right, those who argue that it's a collective right limited to the militia are making a federalism argument. The federalism argument is that the framers wanted to have state control over the militia as a counterbalance to an overweening federal government. And now I think that's an incorrect reading of the history, or at least only a partial reading of the history, but it's not totally implausible. Uh, the states fear the federal government. Because they fear the federal government, they want a constitutional provision to protect the state militias from the federal government. Okay, again, I think historically inaccurate, but not implausible. Okay, now let's look at Salina. Salina is basically a state court saying we have a state constitutional provision, and Salina is reading this Kansas Constitution, not the federal Constitution. We have a provision in our state constitution, um, which is basically designed to prevent the state government from disarming its own militia. That doesn't make sense. I can see why a state government would fear potentially the federal government trying to disarm its militia. Why does the state government fear that its own legislature is going to disarm the militia? It makes no sense. What I think does make sense is these are people who simply supported certain kinds of gun control, and a reinterpretation of the state constitutional right to keep and bear arms provision was necessary to achieve the policy objectives that they wanted. And that's something I think we might want to think about in terms of the collective rights theory more generally. I think the very fact that it comes out of state constitutional law first may very well be a good indication that this is not an accurate reading of what was intended by these provisions.
Yeah, that's a great point. Um, so then the First World War comes, and did that have any impact on the way Americans viewed their right to keep and bear arms?
Um, Not necessarily directly. Of course, one of the things that happens is more people, because of mass mobilization, get familiarized with firearms that might not have otherwise been. Um, Also, there's a parallel discussion that we have in the book of what exactly is the militia, and the standard reading is, well, the militia kind of went out of existence in the 19th century, partly because of failures in the invasion of Canada in the War of 1812 or whatever reasons. But one of the things we need to think of in terms of militias is the idea that the Home Guard is really the modern version of the militia. That yes, when the army is sent overseas, when the National Guard is put into the army and also goes overseas, who is guarding various installations and other valuable areas? And it's the Home Guard, and that's there is a robust Home Guard movement during the First World War, guarding against sabotage and other matters. But I think what probably the greatest contribution the World War One actually makes to this is that um, it brings about a whole new set of weapons after the war that the public becomes familiar with, namely automatic weapons, and the most famous of which is the Thompson submachine gun, or Tommy gun. And that plays a role in um, spurring support for what would become the National Firearms Act of 1934. So I think that might be the indirect role that World War One has to play in this discussion.
That brings us well into the 1930s, which was a relatively eventful decade for the Second Amendment.
Mhm.
First came the National Firearms Act, as you mentioned, of 1934. Can you, I know it's another kind of broad question, but can you discuss the NFA a little bit?
Okay, I think one of the things we might want, I mean, those of us who study the Second Amendment and the firearms issue um, need to look at the NFA in a broader context, which is, I think, that what happened. One way of looking at the NFA is it's part of the New Deal's uh, redefinition of the scope of congressional power. That is to say, um, prior to the First World War, let's say, or even prior to the New Deal, I think most people would have agreed that any kind of legislation prohibiting or restricting firearms was simply beyond the scope of Congress's abilities, scope of Congress's powers, regardless of the Second Amendment. People would have simply said Congress does not have the power to simply, ban or put a strong tax on automatic weapons or any other kind of weapon. What we have with the Roosevelt administration in the 30s is a push to expand and redefine uh, the power of the federal government so that the commerce power and the tax power are viewed, are re-examined, reconceived, as it were. And we come out of that, out of the 30s, with very much the idea that Congress has incredibly expanded powers, far broader than certainly would have been conceived of in, let's say, the 1780s, 1790s, when the Constitution is being drafted. So I think we want to look at the 1934 National Firearms Act within this context, within the context of a greatly expanded, for better and worse, I might add, power of Congress to regulate things. And with that, we've got the 1934 Act, which puts what was then a stiff tax on automatic weapons and short-barreled rifles and shotguns. And there is an effort to include handguns, but I think the NRA, in its first federal outing in terms of federal legislation, manages to stop that aspect.
The next comes Supreme Court case, U.S. versus Miller in 1939. Um, can you provide a summary of Miller?
Yes. Uh, Miller is basically handling a short-barreled shotgun. He's arrested for violation. He doesn't have a tax stamp for violation of the 1934 Act. The district court quashes the indictment on the grounds that the act is a violation of the 34 National Firearms Act. The federal government is in a position where its legislation has been declared unconstitutional. Federal government goes to the Supreme Court to argue that the 34 Act is constitutional, is not a violation of the Second Amendment. Interestingly enough, it's an ex parte hearing. Miller, when the indictment is quashed, basically leaves the scene. So nobody is representing the opposite of the federal government's point of view. The federal government throws out three theories. One, that the Second Amendment only applies to the militias and not the individual. The other, that it's under the common law, the government always had the right to regulate under the common law. And then finally, a theory that some firearms are protected by the Second Amendment, some are not, and those that are not are essentially gangster weapons that are not suitable for militia use. The Supreme Court basically takes that point of view, that only firearms which are usable for militia use have constitutional protection. Now that leaves all sorts of questions still open. Does that mean every firearm which is suitable for militia use is protected, or only a subset of those particular firearms? So, one could argue, for example, that, well, certainly automatic weapons would be suitable for militia use, though one thing that should be said, uh, considering that this is a case which is occurring in 39, the standard weapon of the U.S. Army at that point is the bolt action 30-06 Springfield, which had a 5-shot magazine. Uh, Automatic weapons like the Thompson submachine gun or the Browning automatic rifle were specialty weapons. Would they have been protected as well? The Supreme Court doesn't answer those questions, and in part they do because they don't, because they're part of an ex parte hearing and nobody's really raising the other side or raising other questions. So the court makes its decision in Miller. It basically says a weapon has to be suitable for militia purposes, but then doesn't really go beyond that. And that ends up being sort of the Supreme Court's last word on the subject, really, in a case that's directly on point until Heller.
So soon after Miller was decided, World War II began. The Home Guards, you touched on this earlier, talking about World War One. They were established in many states during both World Wars, and I think they're too often overlooked part of history. Who served in the Home Guards, and what role did they have in the Second World War?
Well, it depended on obviously on which nation. Britain, when it's expecting an invasion, starts bringing a number of men who are either too young or too old for military service or who are in exempt professions. And they basically have them on a part-time basis guarding areas. And in some ways, it's sort of an effort to free a regular soldier for frontline duty. So they can guard bridges, warehouses, other areas with inside of the UK. Um, you have similar efforts established in the United States during the Second World War, and I believe we also mentioned a parallel effort which existed in Canada. I think they were called the Northwest Rangers as such. And the whole idea is you need people guarding various installations and locations in home territory, even though they're not particularly likely to see combat. But nonetheless, do you want to place regular soldiers in those positions and take them away from, the fighting fronts, as it were? Or do you want to have lightly trained civilians to do that, essentially becoming the 20th century version of the militia? And by the way, this is something wasn't simply confined to the United States. As Nazi Germany is being overrun, um, it forms something that was called the Volkssturm, which basically was a militia, essentially a last-ditch effort to try and stop the Allied forces from overrunning Germany. Japan had plans to have something of that sort also, but the invasion, of course, didn't occur because of the atomic bombing. Um, so this idea that the population as a whole might, even civilians, might in fact be called upon in defense of the state is one that extends, well into modern times as such.
There's I should mention there's a good book on the American. I think it's called The American Home Guard by Barry Stenniford, which is somewhere on the shelf behind me there. Which
Okay.
for anyone who wants to read a whole, 250 or 300 pages on the Home Guard. But
Well,
anyways,
one of the more interesting groups that fit into that category was a group called the Coast Guard, U.S. Coast Guard Temporary Reserve. And what happened was, if you were a boat owner, a yacht perhaps, or a fishing vessel or whatnot, the Coast Guard would give you temporary rank in the Coast Guard. And they gave these individuals for their boats machine guns, depth charges, and whatnot, and basically asked them to hunt for German U-boats. 1942 and 43 was particularly bad in terms of U-boats sinking, merchant shipping off the east and Gulf coasts, and the Navy and Coast Guard were simply too not enough of them to really try and stem that. So they essentially deputized civilians to aid in the effort.
So you mentioned earlier that a real gun control push started in the 1960s. This followed the assassinations of President Kennedy, his brother Robert Kennedy, and Martin Luther King. And this is where the collective rights interpretation of the American Second Amendment really took off. Can you explain how that interpretation really entered the mainstream debate?
Well, okay, one of the things I should probably say is, look, uh, there are a number of different collective rights arguments. Um, and uh, they coalesce into what we would see in the United States from the 1960s on. If we go back for a second to Salinas versus Blakesley, the Kansas case, I think that a close reading of what the court did in that case um, was basically to say that the right to bear arms was a collective right, um, but that it really didn't address the question of the right to keep arms. So, what we had was an individual in Salina who was in a bar fight, I think, and he had a gun, was arrested, and the court says basically the right to bear arms is a collective right. It didn't address the right to have an arm or the right to keep an arm. And that was because that wasn't the issue before the court. The person wasn't arrested for having a gun in his home. He was arrested for misusing a gun in a bar. If we then fast forward to the 1960s and early 1970s, there had always been uh, gun control advocates in the sense that there were people who wanted restrictions on individuals carrying guns outside the home. Um, and they met with various successes and failures in history, in American history. But by the time you get to the late 1960s, something else is happening, which is the gun control movement has shifted from being a movement that says we want to control people carrying guns in public to people who are saying the very ownership of guns is suspect. And with that um, also comes, I think, a reinvigoration, if you will, of the collective rights theory that is now no longer saying, that the right to bear arms is dependent on a militia nexus, but the very right to own arms is dependent on such, and there is no protection in the Second Amendment for the right to for the right to have arms of any sort. And the gun control movement gains the support of uh, the bar, the elites of the bar, many university professors, and particularly it gains the support of the press. And the press becomes one of the mainstays of the gun control movement. So, in a sense, the press, I would argue, pumps up and gives life or oxygen to the militia-only view by constant drumbeat in editorial pages and the newspapers and the TV and so forth and so on. So it appears that, that there's mass sentiment supporting this idea that the Second Amendment doesn't protect an individual right. However, what people are missing is the people are not buying it. Even during the height of the gun control movement in the 70s, when you virtually can't see anything else in the major media, the TV, the national newspapers and such. Polls are indicating that the American people are rejecting this idea that it simply applies to the militia. People were very often saying it only applies to the National Guard as such. And another important thing happens in the 70s. There's a referendum in Massachusetts to ban handguns. And basically, the gun control movement says Massachusetts is the most liberal state in the country. In 72, it voted for George McGovern when the rest of the country voted for Richard Nixon. We can certainly convince the people of Massachusetts, the good liberals of Massachusetts, to support a handgun ban. It fails. And one of the things that failure indicates, there's a real difference between the public image that is being generated by the press, by TV, by the movies, etc., and what average Americans are thinking, even average liberals are thinking. And that, I think, is a very important lesson that comes out of the 70s, that yes, there's a movement of the elites that really wants widespread bans on firearms ownership, and people aren't buying it. Even liberals who you might expect to support it are not buying it.
I think you include some polls and or cite some polls in the book showing that even at the height of the collective rights push, over 80% of Americans viewed their right as being an individual right, which is something you don't hear much now about
Well,
that period of the debate.
yeah. Well, people can read. The right of the people to keep and bear arms shall not be infringed does not mean the right of the state to have a National Guard shall not be infringed. It's not the same thing. The English language has its demands.
And you also touched on, which brings me nicely into the next question, how it was kind of, you characterized the debate in a way that hadn't occurred to me, where it was sort of elites against elites pushing one thing and then kind of ordinary people believing something else. And this is consistent with, a lot of the collective rights scholarship was appearing in top journals from Ivy League schools or top history journals, that kind of stuff.
Well, okay, I'm not sure I would quite characterize it that way, because when you look at the scholarship that was being done, I mean, one of the interesting things is um, if you look at the 50s, 60s, and even early 70s, there's very little scholarship being done at all. It's not a matter that you've got people who are doing research and making the collective rights argument. And in fact, I think what was very interesting, Roscoe Pound, who is, among other things, dean of Harvard Law School in the 1950s, writes and says, "Yeah, it's the right of individuals, and the court should basically nullify it, deny it." But it's not that there's a significant body of scholarship in, let's say, the 60s and 70s making the case for the collective right. I think there's a sort of almost arrogance of power, which is you've got again the major media sort of saying, just on their own without any evidence. One incident that I found very interesting. Um, in 1976 is obviously the 200th anniversary of the revolution, and I believe it was Newsweek had something on the Bill of Rights at that time. And Now they had drawings illustrating the various provisions of the Bill of Rights, a printing press, and so forth and so on for the First Amendment and whatnot. And then they came to the Second Amendment, and they basically had militiamen. They had Continental Army soldiers all in, blue regulation uniforms or jackets. Well, that was not the militia, which they were trying to, in fact, convince people was what the Second Amendment was about. Well, that's not what the militia looked like. That is dressed in regulation uniforms with uniform weapons and so forth and so on. But anyhow, I guess just to back up, a lot of people were making the case or loudly proclaiming that the Second Amendment only applied to the militia, but they didn't show any evidence for it. It was not based on scholarship. It was just basically, we're the press and we say that that's what it is.
So then in the 1980s, some scholarship, notably from, well, I don't want to omit anyone, but Don Cates, Stephen Holbrook, Dave Hardy, etc., really comes and starts focusing on the history and elucidating that the Second Amendment protected an individual right. Can you tell us more about the scholarship from that time?
Well, you have several people. First of all, I think the person who probably deserves the most credit in terms of making the individual rights view intellectually respectable in the modern era is Don Cates, and though I would also give a lot of credit to Stephen Halbrook and David Hardy, those three in particular. But then also, you begin getting more and more people in the both the arts and science and the legal academies investigating the issue and saying, yeah, there's really something there. I'm thinking of Robert Shalhoub, who writes in the Journal of American History, Joyce Malcolm, a historian who writes the book To Keep and Bear Arms, The Origins of an Anglo-American Right. Um, and then Sanford Levinson at the University of Texas, who in the Yale Law Journal says, yeah, all these people who are saying this are basically they basically are onto something. And I think that sort of changes the universe in terms of an intellectual acceptability of the individual rights argument. And there, from then on, it becomes a staple of debate in law journals and other kind of journals.
So two of the major issues the book guides us through the history of were resolved by the Supreme Court in 2008 and then 2010.
Yeah.
Starting with the court's 2008 decision in District of Columbia versus Heller. You provide fascinating history in the book of what went on kind of behind the scenes in both of those cases. But for the purposes of this interview, can you tell us where the Supreme Court came down on the question of whether the Second Amendment protects an individual or collective right?
Oh, in District of Columbia versus Heller, it comes down squarely in favor of the individual right. Absolutely no question about it. Now, it's a narrow decision. It's a 5-4 decision at the time. But it's clear that it's looked at that Justice Scalia, who writes the opinion, sees it as an individual right and whose primary purpose is individual self-defense, which is somewhat different, I think, from what the Miller Court does in 39. The Miller Court says one has an individual right uh, to have weapons, to have arms, so that if one is called to militia duty, one has the arms with which to perform it. Scalia acknowledges that point, but Scalia says the primary purpose is individual self-defense, and in the case of Heller, the right to defend your home with a firearm. So yeah, it becomes uh, squarely a right of individuals in that case.
Then, because Heller involved the District of Columbia's handgun ban, it did not answer the question of whether the Second Amendment prevents states from violating the right to keep and bear arms. But that question was soon resolved in the 2010 case, McDonald versus City of Chicago, which
Right.
involves Chicago's handgun ban. Can you tell us how the court ruled on that issue?
Yes, the court basically said that the Second Amendment applies to the states as well, so that the state government cannot violate the Second Amendment any more than the federal government could. District of Columbia was initially selected precisely because it's federal territory. Uh, so that there was no the issue wouldn't get confused with what's called the incorporation issue, the extent to which a provision of the Bill of Rights applies to the states. So with the District of Columbia, you had a clear federal case. This is the federal government violating the individual's right. Once the right is established, then the idea was let's move to to a state that's violating. And here, the city of Chicago and some other towns in Illinois had bans on the ownership of handguns, somewhat similar to the DC ban. So you could go right to that and say, okay, does this now apply to states and subdivisions of states, which the Supreme Court said it did. Now, it's interesting, you had a sort of split in the Supreme Court with four justices saying that uh, this was a violation of the Due Process Clause of the 14th Amendment, which had been the traditional way for the Supreme Court to apply a provision of the Bill of Rights to the states. But with Justice Thomas going back to the original history of the 14th Amendment and saying this was a violation of the Privileges or Immunities Clause of the 14th Amendment. So it's interesting that you had two theories by which the court, members of the court were saying that this was a violation of both the 14th and the Second Amendment.
Yeah, so the book again that we've been discussing today is To Trust the People with Arms, the Supreme Court and the Second Amendment. And again, Professor Robert Cottrell and co-authored with Brandon Denning. Where can people find maybe not just this book, but some of your other scholarship?
Well, this book can be found on Amazon. It might be the easiest way to get it. Also, one could write to the University Press of Kansas, which was the publisher, and they sell it, via their catalog. So either way would be fine.
Oh, thank you. Thank you so much for coming on today and sharing some of your knowledge with us.
Well, thank you. I enjoyed it.